Online with Terry Jeffrey, a CNSnews.com production.
Hi, and welcome to this edition of Online with Terry Jeffrey. Our guest today is Carrie Severino, the Chief Counsel of the Judicial Crisis Network. Severino was previously a Dean's Visiting Scholar at Georgetown Law Center. She earned her undergraduate degree at Duke, a master's in linguistics from Michigan State, and a law degree from Harvard. She clerked for Supreme Court Justice Clarence Thomas and for Appellate Court Judge David Santel. She is here today to talk about the Freedom of Information Act requests that have been submitted by CNSnews.com and also by her group, the Judicial Crisis Network. The question that these FOIAs go to are whether Supreme Court Justice Elena Kagan needs to recuse herself from the cases involving healthcare legislation that President Obama signed. Carrie, thanks for coming in.
Thanks for having me, Jerry.
Appreciate it. Now, we all know that the litigation over President Obama's healthcare law is eventually going to reach the Supreme Court. Virginia has a suit that it filed the same day that President Obama signed the law, March 23rd, 2010. Florida has a suit that it filed on that same day. It's been joined by about 25 states. You actually have a majority of the states in the union challenging this law in the courts. This could end up being eventually one of the biggest Supreme Court's decisions of the last 4 or 5 decades. Certainly will have a significant impact on American life. I'd like to sort of lay the legal predicate for the question here. There is a law, 28 U.S. Code 455, and it says that any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might be reasonably questioned. That's the first prong of the law. It goes on to say, among other things, that a person who has served in governmental employment and in such a capacity participate as counsel, advisor, or material witness concerning the proceeding or expressed an opinion concerning the merits of the particular case in controversy must recuse. Now, is there any reason to believe that this law does not apply to Justice Kagan?
Well, this law, I believe, does apply to Justice Kagan. There's additionally a code of professional conduct for judges that technically only applies to judges up to the Supreme Court level. So there's those, but it's very similar lines. But it seems this law would apply specifically by its terms to her, any justice of the United States.
Right. So, and she did, in fact, in her questionnaire to the Senate Judiciary Committee, say that she would be governed by the letter and spirit of this specific law. She did stipulate that. Now, to the layperson, I'm not a lawyer, I read this, and it says, any justice shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. Now, just starting there, Elena Kagan was the Solicitor General of the United States appointed by President Obama. Her job as Solicitor General, as I understand it, was to defend the Obama administration's position in disputes in federal court. While she was Solicitor General, the main thing that President Obama did in that part of his presidency was propose health care legislation that was debated in a very heated debate nationwide, was deliberated by Congress, was passed by the Senate on December 24th, 2009, and was immediately threatened with lawsuits by, among others, the Attorney General of the state of Florida. The New York Times in 2009 actually reported that there were 12 states looking at possibly suing. Why should anybody think that there wasn't a reasonable basis for questioning Elena's impartiality on the constitutionality of that law?
Well, I'll tell you the angle I think, though. I think there really is, or there certainly right now are reasonable questions out there that we need answers to.
Right.
I'm assuming that, for example, when we're talking about the merits of a particular case in controversy, that you might see them trying to thread the needle of saying, well, this particular case, she's never expressed any opinion on. Of course, the case was filed after she was made known that she was on the short list for a Supreme Court seat, and after she was aware that she would need to start recusing herself.
But had not been nominated.
Had not been nominated yet, that's right. The case was filed in March and she was nominated in May. But it's possible that she had started to step back from things at that point, although she suggests that in testimony that she was continuing to maintain her role as Solicitor General and act in that manner. But now we're seeing that there were discussions going on ahead of time, as early as January, about these issues. And one could try to argue, okay, that wasn't talking about this particular case because this particular case
Right.
didn't exist. However, they were expressly attempting to predict the arguments that would be brought in a case that, as you said, everyone was looking for since 2009.
But I want to get into the nitty-gritty, and we'll actually go through what some of these email communications that the Justice Department has released to cnsnews.com and are now public, what they say. But on that first threshold question, again for the layperson, that a justice shall disqualify. Now, it seems to me that's a mandate, right?
Right.
It's not optional. She must do it if this criteria applies.
Right.
Okay, and then it says, in any proceeding in which his impartiality might be reasonably questioned. So, if I take your meaning correctly, any proceeding, they may try and get out of it that way. I mean, this prong of the law, that this particular case, the Florida-Virginia case, she wasn't involved in.
I think the other angle they'll look at is what the word reasonable means.
Uh-huh.
And because the reasonableness standard should be interpreted as the reasonable man knowing all of the relevant facts. So, for example, people might have reasonably questioned that Justice Scalia should have recused himself from a case on which Vice President Cheney was listed as a plaintiff because he had gone duck hunting. But Justice Scalia said, look, if you had known, the reasonable man would know the fact that we had no conversation about this. The way that he's listed on the case is just ex officio. He doesn't really have anything to do with the case personally. And if you know the actual circumstances, there aren't any reasonable questions.
Right.
So it's possible that she really, even though she was Solicitor General, and even though the Obama administration was actively involved in trying to defend both preemptively and post-filing against these suits, that she really did never have anything, in any discussion about it, it just never came up. So that's possible, and if that's the case, then yeah, she couldn't reasonably question.
This part of the law that says impartiality. Mm-hmm. Would it have been reasonable for President Obama to nominate his own Solicitor General to the Supreme Court on May 10th if he believed that she would rule against the highly controversial law that he had signed on March 23rd and already was being challenged in federal court?
I think it's incredibly unlikely that if he thought she was going to be automatically recused that he would have nominated her. I think that's why Elena Kagan was so careful, and as a lot of the emails that you've uncovered indicate, she has been very careful not to leave a trail, and maybe she's been careful enough not to actually say anything on this topic. But that definitely paints a picture of her as a very calculated individual trying to, advance her career even at the cost of not fully fulfilling her role as Solicitor General. So if she really had no contact with this, it's hard to imagine that she was really fulfilling her role as Solicitor General at the time.
All right, and then the second prong of that law that seems to be relevant is whether she expressed an opinion about it. It's one thing to reasonably question her impartiality. It's another thing whether she was talking to someone and she said, you know what, I think the administration should win this case because of, or the health care bill is actually constitutional despite these claims because of. If she had that kind of conversation, she has to recuse?
Sure, but if it's also possible to give some of those information without perhaps think like a lawyer. Think like, what is the definition of is?
Right.
If that's the way you're looking at it, there might be ways for her to try to, again, thread the needle on this. Now, certainly that would violate the spirit of the law, and if they.
But she said she would be governed by the spirit of the law.
She said she would be governed by the spirit of the law, and also there are codes of conduct and just judicial. The respect due to judges also. The judges also are required to have respect for the office and not create appearance of impropriety.
Okay, let's look at some hard facts that we know now, either from the record that she submitted to the Senate Judiciary Committee or from the emails that they released to CNS News. First, when after her Kagan's confirmation hearings, but before she was actually confirmed in July of 2010, the Republicans on the Senate committee sent her a series of questions about the health care litigation. And in one of them, they asked, have you ever been asked about your opinion regarding the underlying legal or constitutional issues related to any proposed health care legislation, including but not limited to Public Law number 111-148, which is the health care law, or the underlying legal or constitutional issues related to potential litigation resulting from such legislation. So this is a very broad question. They didn't limit it just to the health care law President Obama signed. It was challenged by Florida and Virginia. They're saying any health care legislation. She gave a flat response of no. They then turned around, these Republican senators in the Judiciary Committee, and they asked basically the same question, but they asked her whether she had ever offered any views or comments as opposed to whether she'd ever been asked her opinion. And again, she said no. Now, do these answers that Elena Kagan gave in writing to the Senate Judiciary Committee Republicans, do they carry the same weight as sworn testimony where she says, I swear to tell the truth, so help me God?
Yeah. I mean, if these are incorrect, then she has perjured herself. Although I think Elena Kagan is smart enough not to have done so.
Right.
So even, but again, both of these questions go to the third part 3 of 28 U.S.C. 455 that we were talking about. Has she, while in government employment, participated in the proceeding or expressed an opinion concerning the merits of the particular case in controversy? They don't necessarily go to, there are a lot of other situations where her impartiality still might reasonably be questioned.
Right.
So it's possible that, first of all, that she was either trying to slice the words a little too thin and thought she was answering this accurately, but there are other discussions she had that could fit in there. But I think it's also very possible that there are things that she did that she may be accurate. I didn't offer my opinion, views, or comments on these issues, but still that her partiality could be seen.
So taken at face value, her statement that she never was asked or offered her opinion regarding the underlying legal or constitutional issues related to any proposed health care legislation. We have to take it at face value that on pain of perjury, that's what she's saying. She never discussed the legal or constitutional underlying issues of any health care legislation. Right. While she was serving as Solicitor General and the health care law was being passed.
Exactly.
All right.
Exactly. Although would that cover, for example, if someone said, what are some of the issues they might bring up? Don't tell me what your opinion of them is. Don't tell me if you think they're going to win. We're just brainstorming. What are the things they might bring up?
Right.
I don't know. That's things like that might be a fuzzy thing where, is that technically my opinion regarding the underlying legal claims?
Uh-huh.
Not necessarily. So there could be discussions she could have had about those issues that might not fit into
the words health care could have come out of her mouth. Health care legislation could have come out of her mouth.
Possible.
But
it might be too smart to have actually referred to it in the explicit term.
All right, now, let's look at an event that December 24th, 2010, Senate passes the health care bill that President Obama eventually signs into law. Shortly thereafter, the Attorney General of the state of Florida starts raising constitutional questions about it. By December 30th, the New York Times is running a story saying that maybe as many as 12 states are looking at lawsuits. And on January 8th, 2010, at 10:54 in the morning, Brian Houck, who is a lawyer who works in the office of the Associate Attorney General Thomas Pirelli, sends an email to Neil Katyal, who is the Principal Deputy Solicitor General. He's the immediate subordinate of Elena Kagan. And significantly, he is the person who has now signed the briefs that have been submitted in federal appellate court on the Florida and the Virginia cases. He is the lawyer representing the federal government. So Houck says to Katyal in this email, "Hi Neil, Tom wants to put together a group to get thinking about how to defend against inevitable challenges to the health care proposals that are pending and hope that OSG, namely the Office of Solicitor General, could participate. Could you figure out the right person or people for that? More the merrier. He is hoping to meet next week if we can. Thanks, Brian." Okay, that was 10:54 a.m. 10:57 a.m., 3 minutes later, Neil Katyal sends an email back to Houck, and he says, absolutely right on, let's crush them. I'll speak with Elena and designate someone. So here's Elena Kagan's top deputy saying to the guy in the Associate Attorney General's office, let's crush the inevitable challenges to the health care law, January 2010. That's 10:57 a.m. Now, at 10:57:38 a.m., 38 seconds later, he sends an email to Elena Kagan that does not include the email that says, let's crush them, but does include the email from Houck about the meeting. And he says, Katyal says to Kagan, I'm happy to do this if you are okay with it. Otherwise, Ed, and I take that to mean Ed Neither, who's a Deputy Solicitor General, would be the natural person, or both of us. So Katyal is offering to Kagan, hey, I wouldn't mind doing the inevitable healthcare cases. 11:01 a.m., so 2.5 minutes later, Solicitor General Kagan emails back to Katyal, her principal deputy, you should do it. So she's assigning her principal deputy to handle the inevitable challenges to the healthcare bill that the Senate has passed. At 1:05, so then there's a 2-hour delay. At 11:01 a.m., Elena Kagan assigns her deputy Katyal to handle the cases, or the inevitable challenges. 2 hours pass over lunchtime. This is a work day of Friday. And then Katyal emails back to Brian Houck, the Associate Attorney General's office. And he says, Brian, Elena would definitely like OSG to be involved in this set of issues. I will handle this myself along with an assistant from my office. They redacted that person's name. And then Katyal says, and we'll bring Elena in as needed. And then he says that he's, in the rest of the email, he says he's going to be out of town in the following week. Now, does that email suggest to you that Kagan and Katyal had a conversation that day in addition to this email? He's saying that he will bring Elena in as needed and that Elena definitely wants their office involved.
Well, it certainly sounds like he got that information from somewhere. And knowing the chain of command in DOJ, it's hard to imagine he would just impute all of these things to her. Oh, I'm sure she wants us involved, and here's how we're going to do it. It sounds like they must have had a conversation in person to discuss these things. At DOJ, everything is signed off on by 5 or 6 superiors, it seems. So it seems very unlikely that Katyal would just go on a limb and say, this is what Elena wants without checking.
It's a reasonable hypothesis that on that day when the Justice Department decided they were going to mobilize to protect the president's health care proposal from threatened lawsuits, that he actually talked to Kagan about it.
It's very likely. And it's also telling, as you saw, Neil Katyal is not on the fence about the healthcare law. He says, let's crush them. And if she appoints as her representative on this at this meeting about the healthcare thing, someone who's not at all a balanced, well, let's look at the constitutional issues and see if there's a case to be made. No, he wants to crush the opposition to the healthcare law. So this is one of the kinds of things I'm talking about where you say, well, technically in appointing him, she might not be offering an opinion, a view, or a comment, but doesn't it say something and raise reasonable concerns about her impartiality when the person she wants in charge of it is the one who wants to crush them?
Now, if Mr. Katyal, who, by the way, is a very accomplished, brilliant lawyer and has done some great things in his career, if you were on the Obama side, he's the sort of person you'd want arguing this case. But if Katyal had been named to the Supreme Court instead of Elena Kagan in this email surface where he said, let's crush them, would he need to recuse himself from the case?
I think undoubtedly. And besides implying views about the constitutionality of the case, it certainly sounds like he's not partial. He wants it to go down, whether it's for legal or policy reasons.
Okay, now at this moment when Elena Kagan, the Solicitor General, assigned Katyal to deal with what they believed were the inevitable challenges to the health care law, would she have not been doing her job if she thought she was assigning Katyal to lose those cases? And did she more or less have a duty to make sure she was assigning someone who'd win those cases for the administration?
Well, she has a duty as a Solicitor General to try to make all of the good arguments there are to be made in defending laws, and that's certainly what she represented as her view. Her office has said, and this is what Obama said since she left as well. Now, we've found, for example, that with respect to DOMA, the Defense of Marriage Act, there aren't really any reasonable arguments to be made, and so we're going to just abandon some of these things. So their position is not, we're going to defend any law. It's the Obama administration's position is, we're going to defend any law that we think there are reasonable arguments to be made for. So by appointing someone, it doesn't mean I just have to appoint the strongest lawyer to go get him, whatever the case may be. No, she presumably is thinking, if this is a really constitutionally suspect law, we need to maybe advise the administration.
Maybe we should step back like we've stepped back from DOMA.
Certainly. Well,
but they're not stepping back from it.
It looks like they're upping the ante.
If you freeze this moment, it's January 8th, 2010. Justice John Paul Stevens, who Elena Kagan will later replace on the Supreme Court, he's still on the Supreme Court. He has not announced he's going to resign. That comes later in April. So as of this moment, you have to assume that she has not recused herself as Attorney General. Elena Kagan is the full-bore Solicitor General of the United States, appointed by President Obama. Her job is to defend his administration's position in court. His signature legislation has passed 2 weeks before. They believe there are going to be inevitable challenges in court. And she names this guy, Katyal, a brilliant lawyer who that very day is saying, let's crush these inevitable challenges. Now, that's where we are, that moment in time, January 8th. Back to that law, 28 U.S. Code 455, that says a justice shall recuse if their impartiality can be reasonably questioned. Can't someone reasonably question Elena Kagan's impartiality just by where she was and what she was doing January 8th, actually appointing Katyal to defend against the challenges?
I think it definitely raises some questions. Maybe if we knew all the details, we knew that in fact she was gone all week, she never talked to him over lunch, he just made this stuff up. If that's true, okay, maybe it couldn't reasonably be questioned knowing all the facts, but I think it certainly suggests this could be reasonably questioned, and that's why we need to find even more information. This is just opening a huge can of worms. We need to know what's in that can.
All right, so this is what happened January 8th. As it turned out, they actually did have a meeting the following week when Katyal was out of town, and someone reported to him in the emails, and it's in the emails they released. And at that point, he said that he wanted the Office of Solicitor General to be involved in these cases at the DCT, which I take it to mean at the district court,
right.
Which means from the very first instant he wanted them involved. That happens in the second week of January. Now, as you mentioned, it's not till March 5th, 2010, when, according to the questionnaire she filled out for the Senate Judiciary Committee, she says she was contacted by Bob Bauer, the White House counsel, this is Elena Kagan, and Susan Davis, the Deputy White House counsel. And she said, to inform me that the president wished to consider me for a possible Supreme Court vacancy. So as of March 5th, John Paul Stevens is still on the court. He has not announced his retirement. She has not been nominated to the court, but she has been told by the White House that the president wants to consider her for a quote-unquote possible vacancy. All right, then we go to March 21st, 2010. March 21st is actually the day that the House of Representatives passed the health care bill. It's a Sunday. And on that day, Tom Pirelli, who is the Associate Attorney General, who originally was trying to put together the team back in January to defend against the inevitable challenges, he sends out an email to a group of people, including Neil Katyal, and he says, it sounds like we can meet with some of the healthcare policy team tomorrow at 4 to help us prepare for litigation. It has to be over there, namely the White House. Can folks send me the WAVES info, full name, social security number, date of birth, of everyone that should attend as soon as possible? White House wants it tonight if possible. I know we won't get everyone's tonight. Also, we need to think about the key issues, questions for the agenda. There's something that's redacted, but whatever was redacted tops my list, he said. But I know there are others. Tony, Ian, Beth can CIV flesh out what we feel like we need to discuss. Jonathan and LC may have some ideas as well. Thanks, Tom. Now that email, this was on 6:11 and 12 seconds p.m. on Sunday night as the House was finalizing the health care bill. At 6:19 p.m., about 8 minutes later or so, Neil Katyal emails to Elena Kagan. And he says, this is the first I've heard of this. He's forwarding her that email. I think you should go. No, I will regardless, but feel like this is litigation of singular importance. 6:20 p.m., 1 minute later, the Solicitor General, Elena Kagan, emails back to Katyal and says, what's your number? And 2 minutes later, he emails back her phone number to him. What do you make of that exchange?
There's a whole lot of things we can get out of this. One is interesting because it shows that this email is not their preferred method of communication. Phone is not the preferred method of communication here between Elena Kagan and Katyal. They normally aren't discussing things offline here. But this is something she wants to take offline. She doesn't even know his phone number. She says, what's his phone number? But clearly this is an issue Elena Kagan does not want to create a paper trail for. She knows she's on the president's radar. There's a lot of speculation that Justice Stevens is going to retire. He's 90 years old practically, and he'd only hired one clerk, and everyone says, oh, this means he's going to retire. So I think she wants herself to keep herself clean and able to be appointed.
Your interpretation of this is you believe that Elena Kagan at this point does not want to create a record that would force her to be recused from the healthcare case if she's named to the Supreme Court.
That is, she certainly doesn't want to create a record on this, and I think that would be the most logical reasoning. She knows that the president is going to want someone on the court who can sit on this case. They can't afford to lose John Paul Stevens, who is one of the most liberal members of the court, and then just have that spot go away. So suddenly it's 4 relatively conservative members, 3 liberals, and then Anthony Kennedy in the middle on his signature piece of legislation.
So whatever her motivation was, the fact is she did not create a written communication and a record with Katyal on that very important day when this thing was actually being passed. And apparently she didn't go to the meeting. But
which means she purposely stepped back, because it does seem like the kind of meeting where this is where the top tier people are going. So for her not to go is a little strange.
Right.
He certainly thought it was, of course she's going to want to go.
Right.
But I think she obviously was trying to step back from the healthcare litigation even before her nomination.
Right, and if someone were to make an objective judgment about whether Elena Kagan ever did discuss the litigation or discuss the underlying issues, they probably would want to know what took place in the conversation that Mr. Katyal and Elena Kagan had that evening.
This is a huge kind of flashing light in these emails going, something interesting happened here, so interesting she doesn't want us to know what it was.
All right, and we move forward now, and there's a communication a few days later, March 24th, which is one day after the president has signed the bill, and now Florida and Virginia have filed suits. There are active lawsuits in federal court on March 24th, and a person, Michael Dreeben, who is also in Elena Kagan's office, sends an email saying that he'd been at a U.S. Attorney's conference, and the local U.S. attorneys are saying, what do we do about responding to questions and dealing with these suits against the health care bill? And she's a lady in the, that's the civil office, I assume? Yes, the civil office of the Justice Department emails back and said, yes, Tom, Ian, and I had a nationwide conference call yesterday with civil chiefs. A memo also went out the day before. I'm forwarding right after this. Let's discuss if you have ideas about what more to do. Beth Brinkman, who's the other Justice Department lawyer, it seems like she's talking about talking points that have already been created that have been distributed to people in the Justice Department. In that same day, Mr. Dreeben turns around and emails to Kagan and Needler, who's also in this list, Elena and Ed, regarding the message below from this Beth Brinkman, several USAs volunteered that they hoped that our office would be involved in structuring the government's defense of health care. For all I know, we are involved, just want to pass it on. So this is a guy in Solicitor General's office. He assumes that Elena Kagan is involved in this and that the office is involved. And he then, in another email to Elena Kagan, sends her Beth, namely this Beth Brinkman's response, and then yet another email sends Kagan more, and then there's a response from Needler that Needler sends not only to Dreeben but carbons to Kagan saying thanks, but there's no email from Kagan in this set of emails. Right. The day after the health. Now she's not been nominated to the Supreme Court. J.P. Stevens is not retired, or announced he's retiring from the Supreme Court. The case has been filed, and here's two people in the office, her office, who just assume that she's involved in this.
Right, and I believe when he forwards her things, he's also forwarding, as you said, the memo of talking points that Beth had forwarded on. So even if she is not offering her own personal opinion, she certainly is privy to the Justice Department's strategy in this case, and that I think really does raise questions as to her own impartiality.
That seems, now on the face of it, reading the emails, that seems to be the implication that he's forwarding to Kagan the talking points from this other Justice Department lawyer. They did not include that document in the FOIA request response that they gave to us.
That would be a deliberative process kind of exception. They're not going to be able to disclose things about how the Justice Department is deciding strategically to address cases, and that's a legal question they're not going to address it.
Now, if Kagan, say she gets those talking points, she opens them up and reads them, so she's privy to the inside thinking of her own department, obviously, on the health care case. Does that implicate her in having an interest and involvement in the case that therefore she should recuse?
Yeah, I think it's hard to imagine that someone who's been privy to one side's internal deliberations on the topic, say they were a partner in a law firm that's involved in the lawsuit, even if they weren't on it, and they saw all the emails going back and forth, how do we strategize this, and then later might be sitting as a judge on the case. It's hard to imagine, even if they hadn't personally offered opinions in there, that they wouldn't be recused just as a matter of propriety.
Two of her subordinates thought it was a natural thing that she should get this the day after the suit was filed. They assumed she had an interest in it. They assumed she'd want to read it. They'd assumed that she would be involved. And if we could ask her questions that she would answer, we'd want to ask her, did you read it?
That would be a very interesting thing to find out.
Now she says, so that was March 24th. It's not till May 9th, 7 weeks later, that she says in her questionnaire, quote, President Obama informed me on May 9th, 2010, that he wished to nominate me to the Supreme Court. That's what she said. So May 9th, that's January to February, February to March, March to April, April to May. That's almost to the day, 4 months after she assigned Let's Crush Them Neil Katyal to handle the issue.
Exactly.
Okay. And she says in that time she never discussed this issue. Okay, now on May 11th, which is the day after President Obama publicly nominates Elena Kagan to the Supreme Court, Neil Katyal, her principal deputy, who she has assigned to this issue, who's now signed the briefs, later he's going to sign the briefs in this case, he sends out an email to Needler and Stewart, who are both deputy Solicitor General. He says, as I understand it, Elena is going to recuse from all new cases. Are there any CVSGs you have due that's called for the views of the Solicitor General, which come from the Supreme Court, by cutoff in which she has not participated at all, either in meetings, phone calls, discussions with you, etc.? She has participated in all of mine, Katyal says. What about yours? Now, one thing we know from that is it's not until May 11th, again, 4 months after she assigned Katyal to deal with the expected healthcare litigation, that she actually is moving formally to take steps to recuse herself from Solicitor General.
Right. Well, as appropriate. It would be, I mean, I think she's a very confident woman. She certainly has had the Supreme Court on her radar well before she was even Solicitor General. However, I think it would have been even too cocky for her to start recusing herself while she was still on the short list and not even have been nominated.
Right. So back to just a basic question. Is March 23rd, the law is signed, the litigation goes forward in Florida and Virginia. People in the Justice Department clearly are preparing for the case. They're writing talking points, they're thinking about it, they're discussing it, they're sending emails back and forth. At that moment, her office is working on this. She is their boss. She is the acting, unrecused Solicitor General of the United States. Why does that not give her a conflict of interest now in sitting in judgment of that case?
It certainly suggests that I mean, it's possible that, again, she recused herself from all these things, but it would be so, any Solicitor General who would not have been purposely doing things out of the ordinary would clearly be recused. So she would have had to be so, I'm not exactly sure if she even could block herself off enough because if, for example, people send her emails assuming she knows things, she's not officially recused from it.
Right, and we know from this May 11th, 2010, 1:23 p.m. email from Katyal that this is when he's notifying these deputies that day. That's when neither, who'd been in that other email chain, he's saying from now on she's going to recuse herself from new cases.
Right.
So there isn't, she didn't in any documentary form recuse herself before March 23rd.
Yeah.
In other words, do you think it's possible that she might have secretly, personally recused herself from the healthcare case?
I think that's the only possibility that would make it at all acceptable for her to sit on healthcare. But even then, I think there's already enough things here that raises a lot of questions that she still could be, have recused herself adequately, that her partiality.
That a normal person, an intelligent person looking at all these facts, wouldn't reasonably wonder if she wasn't impartial about this case.
Exactly. I mean, just as you said,
it'd be unreasonable.
From her position, knowing nothing more from her position as Solicitor General, her partiality should be questioned. We're finding out more and more that, wow, she's very calculating about how she was trying to stay available for this case. Was she able to pull it off?
Okay, now here's an interesting email. Immediately, Ed Needler, this Deputy Solicitor General, emails back to Katyal on that May 11, 2010, and he's talking to her about, he's talking to her about some cases, and he said to Katyal, the Golden Gate case presents special considerations because of the possible nexus to the health care bill. I think I did have some minimal discussion with her about the case. That's Needler in an email to Katyal on May 11th. Now, the next day, May 12th, when Needler is responding to Katyal's request for tell me about what you did with Elena so we can... Neither emails Katyal says, Golden Gate. I discussed with Elena several times, and then there's something that's redacted from the email. He says, especially now that health care has passed, she may not want to be involved in that brief. I discussed it with Elena several times. He says, now, I don't know what you know about the Golden Gate case, but it's a restaurant association out in San Francisco was contesting a local law in San Francisco that would require employers there to spend money on health care for their employees. It's a local health care mandate, and they challenged it under the federal law, ERISA, which governs health benefit plans and their treatment. And the question was whether or not the Solicitor General that had a call for the views from the Supreme Court would recommend that the Supreme Court take this case up or not. As it turned out, the Solicitor General in May submitted a brief to the Supreme Court saying don't take this case up now because the health care bill that President Obama had signed may have changed aspects of how this should be analyzed. And repeatedly in the Golden Gate brief that the Solicitor General's office submitted to the Supreme Court, they invoked the health care law that President Obama signed. Would the fact that she was discussing that brief with Neither at least raise questions about whether she discussed health care proposals with Neither?
Yes, and actually it also raises questions as to what is meant by some of these terms. I had minimal discussion with her, which minimal apparently means discussing it several times. I would have thought minimal meant maybe having it come up in conversation once, but he thinks discussing it several times. And I believe there were other emails that suggested that he was planning on sending the draft
Right.
to her
I think so.
of this case elsewhere in the emails that came out of your FOIA request. So it seems to me that someone sending me the draft of that they're planning on submitting to the case, presumably for my review, that's what supervisors do, right? That strikes me as more than some minimal discussion. And furthermore, it's actually surprising to me that he says, now that health care is passed, she might not want to be involved, as if that could remedy what the discussions they had had already. So
Right.
she's not going to want to, clearly she doesn't want to get involved in it going forward, but I think it calls into question maybe some of the way that her office is interpreting how much involvement might
Right.
trigger some of these.
Right, and these emails are happening in the 2 days after she's been publicly nominated to the Supreme Court. Presumably this gentleman Needler did not know before that she was going to be named to the Supreme Court. He was simply doing his job working on this Golden Gate case that involved health care. And as you point out, he says in one email on the 11th of May, I think I did have some minimal discussion with her about that case. Now, let me repeat that. He says the Golden Gate case presents special considerations because of the possible nexus to the health care bill. Mr. Needler thought there was a possible connection to the health care bill. That was his immediate thought. He says, I think I did have some minimal discussion with her about that case. The next day, he says about Golden Gate, I discussed with Elena several times. And then there's something redacted. I mean, so it seems to be indisputable that Solicitor General Elena Kagan discussed the Golden Gate case that this guy was preparing a brief on. And he says, especially now that health care has passed, she may not want to be involved in that brief.
And given their final argument, their response, it's hard to imagine how you would have any reasonable discussion about the case without talking about the health care bill.
Right.
And that implies, even if she's not giving her opinion
Right.
as to the constitutionality or the legality of that question, she certainly is saying we're gonna go with assuming this is going to survive constitutional challenge. Otherwise, it wouldn't be
Right.
mooting.
And she was having these discussions with Mr. Needler about this case, which involved a challenge to a healthcare mandate in San Francisco, in which the ultimate brief repeatedly discussed the healthcare bill President Obama signed, even though she would later say to the Senate Judiciary Republicans that she had never discussed the underlying legal or constitutional issues of any proposed healthcare legislation.
Right.
That was a flat no. So she couldn't, given that answer, whatever discussions she had with Needler, she couldn't have possibly discussed underlying legal and constitutional issues having to deal with any proposed health care.
Well, maybe that goes to how she's defining discussed the underlying legal and constitutional issues.
Right.
That's what I mean. It helps to, when you're not sure what someone's doing with language, we might just need to all sit down and have a good discussion of definitions before we can actually get any useful answers, for example, to the Senate Judiciary questions, because maybe her definition of is different.
Then we come up to the end game, at least of the emails the Justice Department has given us. On May 17th, a week after she's been nominated to the Supreme Court, Tracy Schmaler, who's the deputy spokesperson for the U.S. Justice Department, emails to Neil Katyal, who now is handling the healthcare case. And the subject of the email is HCR litigation, healthcare litigation. She says, has Elena been involved in any of that to the extent SG office was consulted? No, you've been point, but expect I'll get this cue. And Katyal emails back to her 1 minute later, and he says, no, she never has been involved in any of it. I've run it for the office and have never discussed the issue with her one bit. And at 1:19, 15 minutes later, Katyal sends an email to Elena Kagan, forwarding Schmaler's email, and says, this is what in his response, this is what I told Tracy about health care, Katyal tells Kagan. And she emails him back a minute later and says to him and Katyal, Kagan emails back to Katyal and Schmaler, the spokesperson. She says, this needs to be coordinated, Tracy. This needs to be coordinated. Tracy, you should not say anything about this before talking to me. What do you make of that?
Well, a few things. One is he never discussed the issue with her at all. This is her principal deputy. Again, this is a very hierarchical office, and Elena Kagan, from the testimony of everyone who's worked with her, is not really a hands-off kind of person. She knows what she wants, and she knows how everything should be run. So if in fact he really never has discussed the issue with her one bit, That's very unusual. He must have been explicitly instructed not to discuss the issue, whatever he's defining as the issue. I think it also is telling that she wants to make sure she has the opportunity to really craft a message here. Again, if she is trying to be very careful about threading a needle with what discussions have and have not happened and making sure she has the correct language, which as a lawyer, she would, and a very smart lawyer, she probably thinks she can do, I think that would reflect. If she really had never, been anywhere near something, if this had happened a year before healthcare, you wouldn't have to have a conversation to discuss how are we going to answer this question, because, oh, no, I've
right.
never had any discussions about it. But if it's important exactly how that message get conveyed, I think that's why you want it.
Well, why couldn't she could have, I suppose, have given Schmaler the same answer she later gave the Senate Judiciary Committee Republicans. She could have said, Tracy, I never discussed not only that health care bill or the underlying legal issues, I never discussed the legal or constitutional issues of any health care proposal. Mm-hmm. But she didn't say that. She said it needed to be coordinated. Now, and you point out, I've run it for the office and have never discussed the issue with her one bit. Now, so from January 8th, 2010, when Elena Kagan assigned Kat Yall, let's crush them, Kat Yall, to handle the issue, till May 9th, 4 months later, when Obama said he was going to name her to the Supreme Court. So she's saying in that period, when all this was going on, when the law was signed, when Virginia and Florida filed their lawsuits, that they never discussed it one bit.
They never discussed the issue. What does that mean? I mean, does that mean the issue of, is the court going to finally decide this is constitutional or not? The issue of, what does the Commerce Clause say versus the Necessary and Proper Clause? I mean, what does he mean by the issue? I don't know, but we know, for example, that he discussed, should the Solicitor General's office be involved in this case with her? Because he said, Elena definitely wants us to be involved in the case. So obviously he means something less than I never have, the words healthcare legislation or litigation have never come out of my mouth in the presence of Elena Kagan. He means some subset of there. So it's really would be interesting to know what exactly, what he mean, what he has and has not.
What exactly he has and what he hasn't talked to her about. All right, there's one more email. This is on June 15th. This is 2 weeks before her actual confirmation hearing in the Senate Judiciary Committee. Neil Katyal emails to Elena Kagan, and the subject line on it is forward connecting you to. Things have been redacted, so we don't know who else is on this email chain. But Katyal says to Kagan, FYI, also AG just told me that he expects a big story out shortly about whether you are recused in healthcare litigation. I went over the timing and that you have been walled off from day one. And then Kagan forwarded that email to someone with an FYI, but they redacted who it was that she sent the email to. What do you make of that?
Well, I think it's very interesting that he says she's been walled off from day one, because we know when is day one is the question. Is day one January when they first started talking about it? Is day one 2009 when it was first getting talked about? Is day one March when she was informed she was on a short list, or when the case was filed? Certainly it doesn't, her day one isn't the very first day one, because we know she was consulted about if the office should be involved. In January they contemplated she might get involved in the case, we'll bring in Elena as needed, was what Kagan said. So she certainly wasn't walled off. That's not how you talk about someone who's walled off from a case. So she wasn't walled off in January. When did they wall off? We know that she certainly was walled off in May. By May 11th, they were saying, let's not get involved in anything new, because now she's been nominated to the Supreme Court. So I think that speaks to, we need to figure out what Neil Katyal's day one, what does he mean by that here? Because there's a lot of different dates that could be a plausible thing, and there's a lot she could have said before his day one.
Now, it's funny that you should ask that question, because I did ask that question to Neil Katyal. On March 25th, I sent a set of written questions to Acting Solicitor General Neil Katyal based on these emails, and asking some of the questions we brought up and the types of questions we brought up here today. But I was trying to answer what seemed to me to be logical and rational questions that these emails would raise. And the response I got from Tracy Schmaler was a statement that I printed in a story earlier. And when I emailed back to her and I asked, is this the totality of the answer that you're going to give me to my questions? She said that yes, because of the ongoing litigation. And so I then followed up with, because it is a matter of ongoing litigation, on April 14th of of this year, I followed up with another set of questions to Mr. Katyal, in which I asked him, was it his position that he couldn't answer these questions because of the ongoing health care litigation? And then I asked him a set of questions that I thought went to the heart of this issue. And Schmaler emailed me back with their original statement, which, by the way, was, during her tenure, former Solicitor General Elena Kagan did not play any substantive role in litigation challenging healthcare reform litigation. And the small number of documents that were released reflect that. That was Schmaler's original statement. But then in my second set of questions to Mr. Katyal, she also emailed me back and she said, also, I think you might be confused about the litigation I was referencing. It's the ongoing FOIA litigation, not the ACA litigation. So the Justice Department's position is that the reason Mr. Katyal cannot answer these questions, and the sort of questions we've been talking about today, is not because of Florida and Virginia's lawsuits against healthcare, but because CNS News right now has a legal action against them seeking further response to our Freedom of Information Act. And your group, Judicial Crisis Network, also has asked them for Freedom of Information Act release of information. What do you make of that argument?
Well, it's interesting because some of the information you're looking at is not actually the kinds of things you could get from a FOIA request. FOIA requests deal with documents, and I would imagine they purposely did not document, say, the discussion where she asked for his phone number, and first discussed whether they should be involved in the case, or any time he may have talked with her about various issues. So you're asking an entirely different set of information.
I'm looking for verbal communications.
Exactly, and
right.
I don't see how that would prejudice their FOIA lawsuit. I think it's any excuse they can give not to give an answer is a satisfactory one, because we know, as the reason you had to file a lawsuit is they weren't exactly forthcoming on giving these documents in the first place, as is typical, I think, of unfortunately the most transparent
Should Mr. Katyal publicly go on the record and answer these questions? What did he and Elena Kagan talk about in January 2010 when she assigned him to the case? What did they talk about on the evening of March 21st when she asked for his phone number? What day does he think was day one when he says she was walled off? What exactly did Mr. Needler and Elena Kagan talk about when they discussed the Golden Gate brief? Should they go on the record and state for the record exactly what happened in those instances?
Well, there's a couple, like the last one, I don't expect them to go on and say, here's the substance of our discussions on a legal strategy matter, but just give me a yes or no. Did you discuss the healthcare case when you were talking about it? And if so, then the recusal question is still really out there. If the answers are so straightforward and so easy, no, I never had any discussions with her about this issue ever, it seems like it'd be simpler for him just to go on the record and say it and put all the questions to rest.
So in other words, if the question is, Mr. Katyal, on January 8th, 2010, you had this exchange of emails with Elena Kagan in which she assigned you to handle the healthcare litigation, and you turned around and said, Elena wants our office involved in this, I'm going to bring her in as needed to the Associate Attorney General's office. Did you discuss the expected healthcare litigation with Elena Kagan on that day, yes or no? If he can answer no, we didn't discuss it. And on March 21st, when we had a phone call, no, we didn't discuss it. In fact, the entire time between January 8th and May 9th, when she discovered she was nominated to the Supreme Court, not once during that time did I discuss with her the healthcare litigation. And if Mr. Needler could also make the same categorical statement that he never discussed healthcare issues or the underlying legal or constitutional issues of the healthcare issue with Elena Kagan, then in your mind it's settled?
Well, there's still, I think there are more questions than even those two specific people can answer that may be out there. But this is why, as you mentioned, we filed a FOIA request trying to follow up, because your documents that were uncovered raised so many questions, as you pointed out, seeing, okay, where else might we find some answers? So instead of, we try to make it cast as broad a net as possible in terms of, are these discussions, all right, maybe they weren't in just the Solicitor General's office, because you were asking about the Solicitor General's office, maybe it was with the administration, any other executive offices, so looking in those areas as well. And also, emails can be deleted. You know, the Department of Justice emails are archived, I believe, after 90 days, but if you're smart, you don't leave your whole email sitting there to become part of the national record. So it's possible there were records that were destroyed. It's possible that they were just lost. At least let us know what they were. Maybe there were notes that have been lost of one of these meetings. And
So if Mr. Katyal and Mr. Needler could answer insofar as they had communications with Elena Kagan, that they never discussed it. That still leaves open the question of what was discussed at Attorney General's meetings that she attended, what conversations she had with the Attorney General of the United States, what conversations she had with people in the White House, whether they're in the White House counsel's office or policy-making people. These would still go to the question of recusal if, in fact, she was discussing the health care case.
certainly, and we know from her own testimony that she said she was present at least one meeting where the healthcare litigation was brought up.
And they did not produce the records of that, by the way.
No, well, yes, naturally. So, so that we know there's at least one meeting out there that we don't have records of, but there must be a record of somewhere, and at least one suggests where are the others? Now, time to sit down and really think: were there other meetings you were at, and where might there be records?
And of course, all this leaves aside the initial question we had, which is whether her impartiality can reasonably be questioned. And ultimately, who is the judge of whether her impartiality can be reasonably questioned?
Ultimately, Elena Kagan is the judge. Justice Kagan is the one who gets to decide whether she recuses herself. And unless these requests produce some irrefutable proof that she has violated, say, 28 U.S.C. 455 in sitting on the case, it ultimately ends up with the Supreme Court Justice, his or herself. Now, they have an office that helps them make these decisions, an ethics office, but you know, they're the highest court in the land. There's not a lot of recourse, unless if it was so. If, for example, it turned out she did perjure herself, which would be hard to imagine, but people do such things. And if she violated that law, then the only backstop would be, say, impeachment, which is you know, I find it hard to believe that as smart a lawyer as her would have done that, but it's something that we need to make sure we.
What is the timeline on the Judicial Crisis Network for you? How is yours going to unfold as we go forward?
I believe there's about a 2-month window they have to respond. We filed ours. It's now been a little less than a month, but the next point that's going to happen in the case, which hasn't happened yet at the Supreme Court, is that there's going to be a decision as to whether or not they're going to allow fast tracking of the Virginia litigation. So it'll be interesting to see whether Justice Kagan sits on the decision whether or not to hear that case before it gets to the appeals court, because that would be very telling as to how she might behave. If she recuses herself there, then it suggests that she's going to probably have to recuse herself later. If she doesn't, then it really brings up the question of should she have.
That's a pretty good indicator. When will the court decide on that?
Well, we actually expected them to decide on that last week. It was scheduled to be discussed at the April 15th conference last Friday, and but on Monday that order did not come out. So it may be that there's someone who's writing an opinion with respect to denying the expedited hearing. I imagine if they were granting it, they would have been expedited in granting it just as was requested. So
if they
it's hard to say.
If they expedited it, when would the Supreme Court hear it?
Then they probably would not be able to still hear it this year because their hearings end at the end of April. So it would be more likely that they would then hear it in the fall. October is the first sitting. So it makes sense they would hear it now.
If they expedite it, the Supreme Court hear it this fall. What if they don't expedite it?
If they don't expedite it, we have to wait for the Fourth Circuit in the Virginia case and the 11th Circuit in all of the other 26 states to come down with an opinion. And that's coming along actually pretty swiftly. There's arguments in May, I believe, for the Virginia case, and all the briefs are due in May at the 11th Circuit. So really, it seems like there's a good chance we would be able to get it into the Supreme Court docket for next term. The one thing that would slow it down would be if one of the parties calls for an en banc discussion where you, instead of having a 3-judge panel, you have the entire sitting of the judges.
So if it's not expedited, it could be to the Supreme Court next spring or by the fall of 2012.
Certainly, yeah. It could be by this fall, even if it's not expedited, because the 11th Circuit Fourth Circuit is known for being fast. Anyway, the 11th Circuit has granted expedited hearing on this, so it's still going to move through quickly.
So, and then at the same time, the clock will be running on these Freedom of Information Act requests to see if the Justice Department releases any more information.
Exactly, and we just hope we can get enough information so that the public can be satisfied, because I think this is what we have so far is opens more doors than it closes. I mean, it really raises a lot of questions. So in order to be able to know that Justice Kagan can sit on this case with propriety, we really have a lot more questions that need to be answered.
If the Obama administration truly believes in transparency, what ought they do?
Oh, the most transparent administration in history should be volunteering this information, but that's not what we've seen. Unfortunately, they've required lawsuits to wrest it out of them. So I unfortunately, not everything is as advertised in campaign slogans.
Carrie Severino, thank you very much.
Thank you.
Appreciate it.
Online with Terry Jeffrey.